Sir, it is now live.
Yeah, thank you, sir.
Okay.
Okay. So first of all, a warm afternoon to each and every dear faculty members, my student. Today, IPR cell, Arts and Science College, Pulgaon, organized one of the important issue for the academics. How to draft and design the patent for an academician. And for this, today's resource person, Dr.Suresh G. Sudke, Associate Professor and Head of the Department, PG, Satara, College of Pharmacy, Satara. Before to proceed this webinar, a state level one day webinar, I highlighted some of the point. We are meeting after a long gap due to the certain examination of the universities, 5th sem, 3rd sem, as well as the 1st sem. So it has not been possible for us to go with the certain webinar. Now it is a totally a free one, March as well as the April. We are making some back-to-back webinar on a different aspects. In a coming week, we are highlighted some of the assertive communication, the persons coming from the TCS, a manager. Another will be the quality assurance from the apotex pharma. Apart from the particularly the competitive examination, the academic director Pune, who talk on the banking examination as well as their soft skill for the interviews. I first of all, thanks to our management, our principal, secretary, and all the respected staff who motivate, boosted to organize such type of the program for the stakeholders. In a pandemic situation, it is not been possible to meet in an offline manner. And for this, in the last 22 months, sir, we conducted near about a 28 program for the stakeholders in a different components of the NAC. And it is just because of the certain guideline which is issued from the IQACs. And for this, I will welcome Dr. Ashok Davande sir, IQAC coordinator and head Department of Microbiology, to give his remark on today's online webinar on how to draft and design a patent for academics. Over to Dr. Ashok Davande sir.
Thank you, sir. Am I audible?
Yeah.
Okay. Good afternoon, one and all. On the behalf of IQAC Arts and Science College, Pulgaon, I welcome today's resource person, Dr. Suresh Sudke sir. I also welcome Principal Dr. B.B. Hadke sir. Word of welcome to all the teacher, participant, and student to this state level webinar. Today's webinar is on drafting and designing the patent for academics. So, in my opinion, conducting such kind of webinar is very important. We know that in a recent year, there is a increase in the number of the entrepreneur. Many young people have chosen entrepreneurship as their career path. So, among them, some have developed their business model. Some may have invented the product, useful product. Not only the entrepreneur, but also the academician also develop useful product through their research for the betterment of the society. So such kind of creation, inventive product are need to be protected from the unauthorized act. So such intellectual property can be protected. So what are the available rights? So all this information and the awareness is very important. So I think today's webinar is the right platform to know all the information regarding the how to draft uh, or the design the patent particular application. So for that we have very experienced resource person. Today they will share their invaluable insight, expertise, and experience with all our attendees. And I'm sure this webinar is beneficial to all the attendees. With this, I once again welcome to all. Thank you, sir. Over to you, sir.
Thank you, sir, for your opening remark. Now I requested organizing secretary Shakil Khan, sir, to say a few words. Over to Shakil Khan, sir.
Thank you, Banginwar, sir. Am I audible, sir?
Yeah.
Good morning, everyone. Dear friend, you know that today our college, Arts and Science College Pulgaon, particularly IPR cell, organizing one-day webinar, state-level webinar on how to draft and design patent for academic. Dear friend, as we know that in day-to-day life in every field, particularly business field and academic, patent draft and designing is very important. So to discuss such a important and useful topic, we have an eminent guest with us, Dr.Suresh Sudke, sir. So I kindly request you all to attend this program sincerely and entirely and note down the important point from this lecture. Thank you, Banginwar, sir. Now is over to Banginwar, sir.
Thank you, sir. Yes, right now our principals are also joined. Am I audible, sir? Hadge, sir. Yeah. So now this is a place to talk on the different aspects or issues basically regarding with the IPR, and one of the part of that IPR is an patent. Right now it is your property. Every procedure, every words, every line in academics right now it is a part and parcel of your particularly the asset. Now you have to protect your asset through the different aspects. There are the certain particularly the agencies are there, patent agencies. Now this is a curriculum part right now. How to draft and how to design your own patent, and there later on it can get a files. Because each and every the academician do their best activities, best research, best particularly the procedures one, and it is their right. Nobody can copy it, so it have to provide it one. And on such a top, today's my colleague Dr. Suresh Sudke, sir, we both working in the same department near about 12 years in Institute of Pharmacy in the same department, Pharmaceutics. We learn many things from us, sir. I introduce today's resource person, Dr. Suresh G. Sudke, sir, presently working as an associate professor and head department in a department of Pharmaceutics, GES, Satara College of Pharmacy, Satara. Sir completed a B.Pharm, M.Pharm, and PhD, a GATE examination. Apart from that, sir completed the PG diploma in clinical research and pharmacovigilance, diploma in regulatory affairs. Sir having a total 20 years of experience. Interested area. Interested area, novel drug delivery system and biopharmaceutics and pharmacokinetics, computational stimulation. Sir already filed the 2 patent, publish it. Sir published near about 27 international paper as well as the national one. Presented national and international conferences 11. Book published 2 as an the author and co-author as an the 4 books in his credit, and wins a best oral and poster presentation at national conference 4 times. Sir already guided near about 15 students for the M.Pharm and 3 student guiding for the PhD under his valuable guidance. Sir also having the university representation for the Avishkar 2019 as a judge, as a trainer and resource person in the faculty development program, short-term training program, as well as the national conference. On this short note, now I requested today's resource person, Dr.Suresh Sudke sir, to open his webinar on topic how to draft and design a patent for academics. Over to Dr. Suresh Sudke sir.
Thank you very much, sir, for your valuable information regarding me, introduction regarding me. So, am I audible, sir, clearly?
Yeah.
So, as such, sir has described very nicely. I am not such a great person here. So, whatever the experience that I have, I am going to discuss over here. So, 1 minute. Sir, please tell me whether the slides are changing or not.
Yes, sir. Yes, sir.
Okay.
Go ahead.
So, my topic of my discussion is now today drafting, how to draft and design the patent for the academics. As such, the topic is very, very easy if you understand it. And it is very, very difficult because it comes through the practice. It is not the thing that you get through one day only. So firstly, what are the intended learning outcomes of today's presentation? So once the participant, they attend this particular webinar, they will able to understand about the intellectual properties. Then the participant, they also know about what is a requirement for the patentability, and they can implement the best practices in the drafting the patents. So firstly, before drafting any patent, we must understand what we can patent. What do you mean by intellectual property? So this intellectual property, it is the legal concept that encompasses the creation of our mind. So it includes mainly its inventions, literature or art, or it may be a symbol, it may be a name, images or design. So in invention, suppose this is the aeroplane and it is carrying a car from one place to the another place. So this is the innovation. This is the invention. And that's why we must protect this. Another example, that is literature. Suppose this is the book that is written by J.K. Rowling, Harry Potter. So here this literature, this novel or this book, it should be preserved, and that is also intellectual property. Then symbols, we know that, all of you know that this is the symbol of apple, and no one can copy this without apple. So this is the intellectual property of that particular company. Or a name, suppose iPhone, and images, you know that when you are searching on the web or internet, you can see the several images are available. But there are mainly two types of images they are available on the internet. One is a licensable and second is a non-licensable. So whatever the licensable images are there and you are using it in your literature, so you have to provide the credit or courtesy to that particular individual. Now, next, design. Suppose this is the design of a car. So it is intellectual property that is for only that particular company. No other company can produce same design of the car. So that is also an example of the intellectual property. Always you keep in your mind that where there is a property, there must be the requirement of the protection. If you are having the property, there is a need of a protection, and the protection it will come through the right. आपल्याला माहित आहे. फॉर एक्झाम्पल आपल्याकडे जर शेत असेल किंवा घर असेल, त्या घराची जी प्रॉपर्टी इट इज अ टाइप ऑफ अगेन अ प्रॉपर्टी, तिला प्रोटेक्ट करणं गरजेचं असतं. आणि प्रोटेक्शन इट कम्स थ्रू द राईट. आपण तिला जर प्रोटेक्ट केलं, पूर्ण डॉक्युमेंट जर आपल्याजवळ असतील, तर त्याचा मालकी हक्क पूर्णपणे आपल्यावरती असतो. मी माझं प्रेझेंटेशन मराठी आणि इंग्लिश भाषेमधून इथं प्रेझेंट करणार आहे. कारण काय की आपल्याला खूप सोप्या आणि इझिएस्ट भाषेमध्ये आपल्याला आपल्या विद्यार्थ्यांना समजून सांगण्याचा माझा प्रयत्न राहील. तर इंटेलेक्च्युअल प्रॉपर्टीज ह्या दोन प्रकारच्या असतात. एकाला आपण म्हणूया कॉर्पोरियल प्रॉपर्टीज आणि दुसऱ्याला म्हणूया इनकॉर्पोरियल प्रॉपर्टीज. आता कॉर्पोरियल प्रॉपर्टीज म्हणजे काय, ज्यांना आपण टच करू शकतो, सेन्स करू शकतो किंवा दॅट परस्यू वी कॅन परस्यू दॅम, त्याला म्हणायचं टँजिबल प्रॉपर्टीज. त्या की मुव्हेबल असू शकतात किंवा इमूव्हेबल असू शकतात. मुव्हेबल मध्ये कुठल्याही प्रकारचं गुड्स घेऊया आपण, किंवा रिअल प्रॉपर्टी म्हणूया, रिअल इस्टेट म्हणूया. सो इट इज द पार्ट ऑफ अ इमूव्हेबल प्रॉपर्टी. Then incorporable properties, we cannot be touched, sensed or perceived. That is called as intellectual or intangible property. आणि याच्यामध्येच आपली इंटेलेक्च्युअल प्रॉपर्टी जी येत असते ती येत असते. So it is intellectual and it provides the right to the individual, and when we are providing right to the individual, there comes a reputation to that particular individual, and therefore in that case the security is very, very necessary. Depending upon that property is depend, or it may be a private property of particular individual or a group of person, they are coming together and they are filing that particular patent. So that is called as the incorporeal properties. So there are two types of properties. First is a tangible, ज्याला आपण सेन्स करू शकतो, ज्याचा आपण ज्याची अनुभूती घेऊ शकतो, त्याला म्हणायचं कॉर्पोरियल प्रॉपर्टी. आणि दुसरी असते इनकॉर्पोरियल प्रॉपर्टी, त्याला म्हणायचं इंटँजिबल प्रॉपर्टी, की जिचा आपण सेन्स पण करू शकत नाही, टच करू शकत नाही आणि अनुभूती सुद्धा घेऊ शकत नाही. आणि म्हणून आपण त्याला म्हणतो इंटँजिबल प्रॉपर्टी और इंटेलेक्च्युअल प्रॉपर्टी. So what are the types of IPR? So this is the basic about the intellectual properties. We can patent, we can have a trademark or trade secret, copyright, then design, protection, and we can have a geographical indications. So today it is not possible within one or 1.5 hour to cover all this, and I am focusing only on the patent in this presentation. So firstly, we must know what do you mean by intellectual property rights. Intellectual property rights म्हणजे काय? So it is the right that is granted by the government of that particular country to the inventor. Inventor, a person who invent that, or a group of person, they invent that particular object, that is called as an inventor. So it is intellectual property. It is an exclusive right that is given by the government of that particular company to the inventor. So he can manufacture, he can use, or he can offer the sale or import or sell the invention for the limited period of time. So from this definition, what we understand? So this intellectual property, it is the right that is given to only inventor, okay, and exclude others. It excludes others, but it is limited to that particular country, and that's why a patent is having the nationality. So if we have filed our patent in US, then it is applicable, it is protected only in US. It will not protected in India. So if you have to protect it in India, you have to make the application in India, and then only you can protect it. This patent, it will not remain for whole life. It is having the shelf life. त्याला एक काहीतरी काल मर्यादा असते, shelf life असते. And we have to renew it every year by paying the annual fees. And its validity is only 20 years after the date of filing. A day on which you file it, after that, it is having the validity of 20 years only. Then it will remain open for the public. So in short, what are the features of the patent? So it is having the shelf life of 20 years from the date of filing. It is having the territory right. What do you mean by territory right? So it is limited for that country, means it is having the nationality, and it is having the exclusive right results in the monopoly. Exclusive right in the monopoly means if I have prepared this particular product, if I have patented this particular product, so I am whole and sole that is given the permission to manufacture, to sell, to import this particular product. And I am only having this authority, or that is called as the monopoly. That is called as the monopoly. So it is the exclusive right that is granted and protected by the law. So these patents, they are having two types of right. One is a positive right and second is a negative right. Positive right means it gives us full authority. Who is an inventor? Inventor is also known as a patentee. So we can only manufacture, we can sell, we can offer to sell, or we can import that particular invention. But the government is having the authority to publish that particular information in the public domain. Now, what is negative right? Negative right means it debars other people to do that particular work, to manufacture, to sell, or to import that particular either method or that particular product. So patentee may or may not exploit the invention. If I am the patentee, I can exploit it, I can commercialize it, or I can sell it to the particular businessman or particular company, so they can manufacture that particular product and sell, and after that he will provide me the royalty for that. So I will get the financial benefit of that. So this is called as a right of the patentee. Next, so before going for any patenting, we must understand what can be patentable and what cannot be patentable. So there are many people, they are just going on increasing the number of patents only. So it is not of very use. There must be a novelty. If you see the functional requirement, there must be a novelty in your work. नाविन्य असलं पाहिजे. Then it is related to the subject matter. ते कुठल्या तरी विषयाशी निगडित असलं पाहिजे. It should not be non-obvious. Non-obvious means it should not be so general. It is available in a surrounding, but it should have utility, commercial application, and industrial applicability. आणि त्याचा समाजासाठी, एन्व्हायरमेंट साठी काहीतरी उपयोग जर झाला असेल तर ते जे पेटेंट आहे ते पेटेंटेबल होऊ शकतं. Then when we consider the procedural requirement, it should be definite. Definiteness is very, very important. If suppose I have patent one procedure, but the next time, if that procedure is followed by anybody else, and if he or she is not getting the result, such a type of a process cannot be patented. There should be a definiteness, there should be a repeatability, there should be a reproducibility of the result after following that particular procedure or that particular method. And enableness. So if I have performed that particular process, I will get the product. Similarly, anybody in Pulgaon, he or she perform that particular experiment, what is going to happen? he should get the result. Am I audible? Am I audible clearly?
Yes, sir.
Okay.
Yes, sir.
Okay. Now we will look at what we cannot patent under the Patent Act 1970 Section 3. Frivolous or claim anything that is obvious natural law. हसण्यासारखी गोष्ट जर असेल, जनरल गोष्ट असेल, फॉर एक्झाम्पल न्यूटन झाडाखाली बसलेले होते, ऍपल डोक्यावर पडलं, ग्रॅव्हिटीचा शोध लागला. ओके, सिंपल लॉ, दॅट इज द लॉ ऑफ ग्रॅव्हिटी. मी झाडाखाली बसलो आणि मी म्हटलं माझ्या डोक्यावर ऑरेंज पडलं. इट इज नॉट द डिफरंट वन, इट इज द नॅचरल ऑब्वियस. सो इट इज नॉट द इनोव्हेशन, and that's why there is no novelty in that. So I cannot patent that. Then conflict to the public order or morality or a law. If we are doing that particular patent or that invention and peoples or public, they are opposing for that, or according to the morality of human being, it is not right, or law, it will not support that, we cannot file that particular patent. If it is producing harm to the human being or animals or plant health or environment, then we cannot patent it. Or if it is a mere discovery of scientific principles. So if there is, just now I have given you one example. Similarly, other scientific principles are also there. So we cannot file the patent on that particular scientific principles. Or we have prepared the abstract from the different theories and we have made the abstract from the different theories together. So also it is the summary of different theories. So it cannot be patented. If you have discovered any new substance or a new non-living thing or a living thing or any organism, you cannot patent it. So it is the discovery, it is not the innovation. There is a big difference between the discovery and innovation. We can file the patent for the invention. Okay, we cannot file the patent for the discoveries. Next, a mere discovery of new form of the drug. You know that. Suppose, for example, new substances, chemical, it is available, and what you are doing, you are preparing its different salt. Okay, or you are preparing its polymorphs. You know that. Suppose carbon is available in two form. If graphite was available first time, from graphite you are preparing its diamond. Then you cannot patent it. It is the natural thing. It is the natural thing. So mere discovery of new property of or new use of the known substance. आता याच्यासाठी मी एक छान उदाहरण देतो तुम्हाला. तुम्ही 12वी मध्ये ऍस्पिरिन नावाचा एक ड्रग शिकले, सगळ्यांना माहिती. सुरुवातीला हा इंट्रोड्यूस केला गेला, हा पेन किलर म्हणून यूज केला गेला, एनाल्जेसिक ज्याला म्हणतात. परंतु त्याचा डोज वाढवत नेल्यानंतर तो अँटी रुमॅटिक ज्याला म्हणतो आपण, जॉईंट पेन साठी त्याची ट्रीटमेंट मध्ये त्याचा यूज करण्यात आला. आणि काही वेळेला जे एनाल्जेसिक डोज आहे त्याच्या खाली जर दिला आपण, तर तो ब्लड क्लॉटिंगच्या अगेन्स्ट काम करतो, म्हणजे अँटीप्लेटलेट हा इफेक्ट त्याचा बघण्यात आलेला आहे. पण असल्या प्रकारचा जो चेंज आहे किंवा एखादा ऍडिशनल यूज आपण त्या पदार्थाचा आपण पेटेंट जो आहे तो भारतामध्ये पेटेंट करू शकत नाही. पण अशा प्रकारचा जो यूज आहे आपण अमेरिकेमध्ये फाईल करू शकतो. अगेन आय हॅव टोल्ड यू, every country has their set of rules for the patent. Then a mere known apparatus or machines. If you are having a machine or particular apparatus, just by changing sides or parts of that machine, and you are preparing a new product, out of that you are just using one new reactant in that, then merely it's just a copy paste type of a work and you cannot patent it. Then now simple example, if I mix two substances together, for example ऍस्प्रिन तुम्हाला माहिती आहे, ऍस्प्रिन इट इज हॅव्हिंग द एनाल्जेसिक ऍक्शन, पेन कमी करायचे काम पडतं. आणि पॅरासिटामॉल सुद्धा आहे, तो सुद्धा काय करतोय, तो सुद्धा पेन कमी करतो आणि ताप पण कमी करतो. जर 10% ऍक्टिव्हिटी ऍस्प्रिनची असेल, 10% ऍक्टिव्हिटी जर पॅरासिटामॉलची असेल दिलेल्या डोजला, आणि दोन्हींची ऍक्टिव्हिटी जर आपण सम केली तर 10 अधिक 10 बरोबर 20% ऍक्टिव्हिटी आपल्याला मिळेल, त्याचा इफेक्ट मिळेल आपल्या शरीरावर. तर याला म्हणायचं फक्त ऍडिटिव्ह इफेक्ट. दिस इज कॉल्ड एज द ऍडिटिव्ह इफेक्ट. ओके, बट if I have given drug A or substance A plus I have given drug B, and instead of 10% individual activity, if I am getting more than 20% activity, then it is known as a potentiation of activity, and in that case I can file a patent. But here I cannot file the patent because 10 plus 10, 1 plus 1 is equal to 2. That is called as addition effect. But 1 plus 1, if it is getting 3, then it is known as a potentiation of effect, and then we can file the patent for that. For example, if you are having a device, if you are having a device and you just make a replacement or rearrangement of the different part in that particular device, it cannot be patented. So any method in the agriculture or horticulture, it is a benefit, it is for the benefit of the human being, and that's why you cannot patent it. Or any procedure, medical, surgical procedure, curative or prophylactic procedure or diagnostic procedure. एखादे डॉक्टर आहे, त्यांचा सर्जरी मध्ये खूप हात चांगला आहे आणि पर्टिक्युलर ऑर्गनची जे सर्जरी जर त्यांना करायची, काय म्हणते, ही मेथड मी डिझाईन केलेली आहे आणि मी याचं पेटेंट घेतो, आता मीच ऑपरेशन करेल जगामध्ये, हे चालणार नाही. इट कॅन नॉट बी पेटेंटेड. देन मॅथमॅटिकल फॉर्म्युला कॅन नॉट बी पेटेंटेड, बट द ऍप्लिकेशन ऑफ द मॅथमॅटिकल इक्वेशन्स they can be patented. Then business method, computer program, algorithm, they cannot be patented, but their applications can be patented. Then traditional knowledge, you know that. Havika, am I audible?
Right.
Okay. If you are having any difficulty, you can post in a chat box. Okay. At the end of the presentation, I will answer you. If it is a traditional knowledge, for example, you know that curcumin is having an antimicrobial activity. Curcumin means haldi jala manto. We have used it in a COVID. It is the traditional knowledge, and US people, they have tried it for the patent, but we have provided them our Vedas, and we have resolved that particular problem. Then a drama, musical or artistic work or method of performing mental act, it cannot be patented under the Patent Act 1970 and Section 3. Now why? We must understand why we should understand the information regarding the patent. Because if you see the different patents, they are not having any financial or economic significance. They are having a technical value. Their commercial value and scientific value is a different one. Okay, and to understand that particular commercial and scientific value of each patent, the patent information is very, very necessary. So at what level the research is going on in that particular patent, if we have to understand that, then we must study the different patents. So if I am going to work on particular patent that is open now after 20 years, I must understand what are my competitors. And I must understand in which country that particular patent is filed and in which country it is not filed, so that I can file it in another country. Okay. Now, if I have a knowledge of the patent that is all around, they are filed, I will not again and again work on the same field. I will not waste my efforts, my time, as well as money. I will not duplicate the work of other people, and that's why I stop the infringement. मी दुसऱ्याच्या कुठल्या माणसाच्या कार्यक्षेत्रामध्ये जाणार नाही आणि त्याच्यामुळे मी कुठल्याही प्रकारचा गुन्हा करणार नाही जेणेकरून मला इम्प्रिजरमेंट किंवा पेनाल्टी होणार नाही. So I will keep watching the upcoming trends. You know that in COVID, maximum research is going on the vaccine as well as the drug discovery. Then various devices, medical devices. So I should have a futuristic approach. भविष्यामध्ये कशाची गरज आहे, we have to identify that. And then we have to work in that particular field. Now, the first and very most important thing for the patentability is the innovation or novelty, or what is new in your patent. First, we must understand what is meant by new. If on 15th of March, I am going to file the patent. So up to filing, no same work was published earlier anywhere in the public domain. Okay. The second thing, published our claim either in India or outside the India. That knowledge is not a common one. It is non-obvious. Second, so it is prior to the public knowledge in India and outside the India. It is not the common knowledge in the public. So it is priorly public use. The public of India, they are not also using that particular object or outside the India also. And it is not found in any public domain, means not in a newspapers, not in a research article or review article or patents or other databases they are available. So this is called as the novelty. आता तुमच्या डोक्यामध्ये प्रश्न हा आहे की नोव्हॅलिटी म्हणजे काय खूप मोठा आहे का, इनोव्हेशन म्हणजे काय खूप मोठा आहे का? नो. हियर I will give a very simple example. Novelty, invention is not very complicated and not very complex. If you are thinking that only complex and complicated inventions they are filed, it's very wrong. Okay, see, a needle, first time it was invented. After that they have given the tip of stainless steel, but it is having more weight. The next needle with the plastic ball on the other side. Again, here from first, second, utility it changes. It will become weightless. This is the another invention. After that, third one, this is for hand saving. शिवण्यासाठी आपण त्याचा वापर करतो, कपडे शिवण्यासाठी. Again, utility it changes. And this one, आपण टीप मारतो ना कपडा फाटल्यानंतर, चुकीची टीप मारल्या जर गेली तर त्याला उसवण्यासाठी याचा यूज केला गेला. So minor, there are minor changes in the needle and they are patented. So for the patentability, the complex or it should be a complicated one, it is not the requirement. It should have applicability. So what is novelty and what is non-obviousness, that I will tell you. Suppose this is the drug. Banginwar sir, am I audible? Banginwar sir?
Yes, go ahead, sir. Go ahead.
Okay. So if this is a drug, a medicine that is having anti-HIV action, but this is a cow urine. Individually, if I have given a cow urine to particular patient, that is not having anti-HIV action. But when I give them together, what will happen? The new mixture that is formed, that increase the activity of this drug 90 times. म्हणजे माझा एका दिवसाचा जो डोज होता, मी जर तो काऊ युरिन सोबत जर दिला तर मी एका दिवसाचा डोज नंतर 90 दिवसापर्यंत तुम्ही वापरू शकता. मी हा जो ड्रग आहे माझा, याची किंमत कमी होऊन जाईल. याचं जे मेडिसिन आहे काऊ युरिन सोबत दिल्याबद्दल, माझा जो प्रॉडक्ट आहे याची किंमत कमी होऊन जाईल. जर मी एका दिवसाचा डोज मी 90 दिवस पेशंटला दिला आणि तो इफेक्टिव्ह असेल तर कमी किमतीमध्ये माझा पेशंट जो आहे त्याला औषधी मिळू शकते. जर अशी गोष्ट असेल तर याला आपण नोव्हॅलिटी म्हणू शकतो, नॉन ऑब्वियसनेस म्हणू शकतो आणि ते आपण पेटेंट करू शकतो. आताच मी तुम्हाला एक दुसरी गोष्ट सांगितली की समजा हा झाला तुमचा ड्रग ए, त्याची इफेक्ट आहे 10%, दुसरा ड्रग आहे त्याचा इफेक्ट झाला 15%, दोन्ही एनाल्जेसिक आहेत, पॅरासिटामॉल आहे एक आणि दुसरा ऍस्प्रिन आहे. म्हणजेच टोटल इफेक्ट किती यायला पाहिजे? 10 अधिक 15 म्हणजे 25% यायला पाहिजे. पण तसं न होता ते जे मिक्सचर आहे त्याचा इफेक्ट जर 95% येत असेल, देन इट इज कॉल्ड ॲज अ पोटेन्शिएशन ऑफ ऍक्शन. इट इज कॉल्ड ॲज अ पोटेन्शिएशन. एका पदार्थामुळे दुसऱ्या पदार्थाची जर ऍक्टिव्हिटी वाढत असेल तर त्याला म्हणायचं पोटेन्शिएशन. आणि हे रिसर्च थ्रू होतं. हे जर आपण जर रिसर्च केली नाही तर ह्या गोष्टी होऊ शकत नाही, म्हणून याला आपण इन्व्हेन्शन म्हणायला पाहिजे. ओके, सो दॅट्स वाय इट इज अ नोव्हेल वन, इट इज अ नॉन ऑब्वियस वन, अँड दॅट इज पेटेंटेबल वन. आता तुम्ही म्हणाल, सगळ्यात सुरुवातीला इंट्रोडक्शन मध्येच मी तुम्हाला सांगितलं पेटेंट फाईल करणं हे खूप सोपं पण आहे जर कळलं तर, आणि फाईल करणं थोडं कठीण पण आहे, कारण इट इज अ टेक्नोलिगल डॉक्युमेंट. You should have a knowledge of technology as well as the legal knowledge. Okay, so one complex inventions are patented. आपल्या डोक्यामध्ये कॉम्प्लेक्स आणि कॉम्प्लिकेटेड इन्व्हेन्शन्स जे असतातच ते पेटेंट होतात. सगळ्यात सोपं उदाहरण देतो, सेफ्टी पिन. ऑन 10th of April 1849 वॉल्टर हंट he issued that particular patent in US. The patent of sewing machine needle was granted in 1854. So they are very, very simple. A tissue paper on 17th century, the patent of tissue paper, it comes. Okay, they are very, very easy one. मग वयाचा आणि पेटेंट फाईल करण्याचा काही संबंध आहे का हे बघूया आपण. A youngest girl to get the patent of 4 years from the Houston, Texas, aid of grasping round knob. आपल्याला माहिती आहे आपल्या घरी एखादी राऊंड नॉब असतो, कुठलं तरी बटन असतं, आणि खूप दिवस वापरल्यानंतर काय होतं ते हातात येत नाही आपल्या, आणि त्याच्यामुळे काय होतं ते चोपडं होऊन जातं. 4 वर्षाच्या मुलीनं त्याला होल्ड करण्याची जी क्लिप आहे ती बनवली आणि ती पेटेंट केली. त्याच्यामुळे काय केलं, त्याचं जे ऍप्लिकेबिलिटी आहे ती त्या गोल बटनाला फिरवण्यासाठी तिनं फाईल केलेली आहे. ओके, देन 6 year बॉय रॉबर्ट पॅच ग्रँटेड अ पेटेंट फॉर टॉय ट्रक. खेळण्यामधला ट्रक त्यानं 1963 साली फाईल केले. सो वयाचा आणि पेटेंटचा काहीही संबंध नाही. आपण 3 Idiot मध्ये बघितलंय. 3 Idiot मध्ये आपण बघितलंय. नेक्स्ट, मग पेटेंट आपण फाईल करायचं तर कुठं करायचं हे सुद्धा ज्ञान आपल्याला असणं गरजेचं आहे. भारतामध्ये 4 ज्युरिडिक्शन आहेत मेन. एक आहे मुंबईमध्ये महाराष्ट्र MP, गोवा गुजरात, छत्तीसगड आणि युनियन टेरिटरी दमन दीव दादरा हवेली नगर. दिल्लीमध्ये सी द नेम्स आर व्हेरी व्हेरी इझी टू अंडरस्टँड. गुजरात गोवा GGMM, छत्तीसगड and union territories of DDD. Okay, very easily you can understand. Himachal Pradesh, Haryana, Uttar Pradesh, Uttarakhand, Jammu and Kashmir, and National Territory of Delhi and Chandigarh. Chennai, Andhra Pradesh, Karnataka, Kerala, Telangana, Tamil Nadu, and union territories of Pondicherry and Lakshadweep. So repetitively initial words are there. And Kolkata is having the head office of the Patent Administration Office. Here, these are the different states. You can, that people from that particular area, they can file their patent to that particular office, either on offline mode, they can go directly to the office, or through the online mode. So what are the different types of patent? पहिले आपल्याला पेटेंट्स वेगवेगळ्या प्रकारचे कुठले आहेत हे समजून घ्यायला पाहिजे. एक असतं युटिलिटी पेटेंट, म्हणजेच त्याच्यामध्ये कुठलीही नवीन गोष्ट किंवा नवीन प्रोसेस जर आपण तयार करत असू किंवा फॉलो करत असू, किंवा एखादी नवीन मशीन बनवत असू, किंवा एखादा आर्टिकल मॅन्युफॅक्चर करत असू, किंवा एखादा नवीन फॉर्म्युला बनवत असू, एनिथिंग दॅट इज न्यू किंवा जुनच आहे. ओके, बट we improve its some quality so that its use, its applicability, it is increased. What is established already there in the market, but that particular product, it is having advanced utility than the existing. So you know that this lamp is there. Initially simple lamp was there, then LED lamps are there. Now the automatic lamps are there. They are working on the Bluetooth depending upon the light that is required in that particular room, they will adjust the light. Okay, it save our energy. So this is called as a utility patent. This is called as the utility patent. Then design patent. It is granted who invent new original ornamental design. I have given one example. तुम्हाला माहिती आहे तनिष्क मध्ये एखादी जर सोन्याच्या दागिन्याची डिझाईन असली तर ते दुसरं कोणी कॉपी करणार नाही. सो दॅट इज कॉल्ड एज अ डिझाईन पॅटर्न. कुठली कार आहे मी आता सांगितलं तुम्हाला कारची एखादी डिझाईन आहे समजा टाटा कंपनीने ती कार तयार केलेली आहे तर दुसरं त्याच डिझाईनची कार कुठली कंपनी मार्केटमध्ये आणू शकणार नाही कमर्शियलाइज करू शकणार नाही. इट इज पेटेंटेड टू दॅट. देन प्लॅन्ड पेटेंट. आता मी तुम्हाला सांगितलं कुठली लिव्हिंग थिंग आणि नॉन लिव्हिंग थिंग आपण इंडियामध्ये पेटेंट करू शकत नाही परंतु ओके यू आर इन्व्हेंटिंग अ न्यू प्लांट that is asexually produced or you have reproduced it asexually to form a new variety of the plant. Then product patent. तर कुठल्याही प्रकारचा जो प्रोडक्ट आहे समजा ही बॉटल आहे बॉटल if I patent this product this is called as a patent product patent and therefore it gives me right if I file the patent of that I can make it I can manufacture it I can sell it or I can import it. So all right they are given to me up to 20 years. Then process patent. If I have used one procedure and through that I got this particular bottle, okay, by following that particular procedure and if I file the patent for that particular process, then that is I have only rights to manufacture this particular product by using only that method. I can manufacture, I can sell it, I can offer to sell or I can import that particular product. So that is called as a process patent. That is called as a process patent. तर आपल्याला वेगवेगळ्या प्रकारचे पेटेंट ऍप्लिकेशन्स काय आहेत हे आपण समजून घ्यायला पाहिजे. ऑर्डिनरी अँड नॉन प्रोव्हिजनल ऍप्लिकेशन जे की दोन प्रकारचं असतं त्याला आपण ऑर्डिनरी नाव असं म्हणतो किंवा नॉन प्रोव्हिजनल असं म्हणतो. आता हे दोन प्रकारचे पहिले जे दोन नाव आहेत ऑर्डिनरी आणि कन्व्हेन्शन ऍप्लिकेशन ओके हे कम्प्लीट स्पेसिफिकेशन जेव्हा देतो आपण त्याला कम्प्लीट ऍप्लिकेशन असाही शब्द आपण वापरतो. कम्प्लीट स्पेसिफिकेशन एकदा फाईल केलं की झालं परत फाईल करायची गरज नसते आपल्याला कुठल्याही प्रकारचे सप्लिमेंट आपल्याला द्यायची गरज नसते. अँड सेकंड इज कॉल्ड ॲज कन्व्हेन्शन ऍप्लिकेशन दॅट इज ऑल्सो नोन एज अ प्रोव्हिजनल ऍप्लिकेशन. त्याच्यामध्ये आपल्याला प्रोव्हिजनल स्पेसिफिकेशन्स आपण त्याच्यामध्ये देत असतो. आता प्रोव्हिजनल म्हणजे काय इफ आय हॅव गॉट द आयडिया अँड आय नो दॅट आय कॅन डू दॅट पर्टिक्युलर and I have to write it I have to get the right for that. माझी जी आयडिया आहे ती कोण घ्यायला नाही पाहिजे म्हणून मी काय करतो प्रायोरिटीवर ते पेटेंट जेव्हा मी फाईल करतो दॅट इज कॉल्ड एज अ कन्व्हेन्शनल ऍप्लिकेशन और दॅट इज कॉल्ड एज अ प्रोव्हिजनल ऍप्लिकेशन. आणि मी ती आयडिया सत्यात उतरवणं गरजेचं आहे ओके. अँड आफ्टर डुईंग दॅट पर्टिक्युलर इन्व्हेन्शन आय हॅव टू फाईल वन्स अगेन अ कम्प्लीट ऍप्लिकेशन within a 1 year. Within a 1 year. So that is known as a convention applications. Then PCT international application. So this is the streamline of application for the international level and different countries they are having the different procedures for that. Similarly, PCT national phase application is also there. It produces the protection in that particular country. Then patent of addition application. So if I have published the patent, already that patent was granted, but if I want to modify anything regarding that product or that process, then I can have an additional application for that particular patent and I can file it to the patent office. Then divisional application. Divisional, एका पेटेंटचे मला एक पेक्षा जास्त पेटेंट्स फाईल करायचे असेल तर त्याला म्हणतो आपण डिव्हिजनल पेटेंट. सगळ्यात पहिली गोष्ट आता आपण बेसिक पार्टवर आलो ड्राफ्टिंग वर. सो हाऊ शुड बी आयडियल पेटेंट. आयडियल पेटेंट हे कसं असायला पाहिजे हे पॉसिबली ब्रॉड असलं पाहिजे. ब्रॉड म्हणजे काय, ब्रॉडेस्ट ॲज पॉसिबल, जेणेकरून आपला जो रिसर्च आहे याच्यामध्ये कोणी आतमध्ये एंटर नाही करायला. Nobody should infringe in our work. So competitor should not copy or compete without permission. कॉम्पिटिटरला जर आपल्या फील्डमध्ये कुठल्या यायचं असेल त्यांना आपली परमिशन घेणार, आणि परमिशन आपण तशी देणार नाही. The competitor should not do work all around. आपल्या आजूबाजूने सुद्धा त्यांनी काम करू शकले नाही पाहिजेत, अशा प्रकारचं आपलं पेटेंट ड्राफ्टिंग असलं पाहिजे. And competitor should not build a similar solution without infringement. जर मी कंपाऊंड ए तयार केलेला आहे तर, आणि मी त्याची प्रोसेस सुद्धा फाईल केलेली आहे, कुठल्या दुसऱ्या मेथडनं माझा कंपाऊंड ए दुसऱ्या कुठल्या कॉम्पिटिटरनं तयार केला नाही पाहिजे. त्यानं जर तयार केला तर तो मला कॉम्पिटिटर येऊ शकतो, आणि तो मला कॉम्पिटिटर आला तर मला जे फायनान्शियल बेनिफिट, कमर्शियल बेनिफिट होऊ शकतात ते होणार नाही. सो if we do so, what will happen? We produce the product without any competition, we'll get the royalty. मग मी काय करेल, मी माझं जे पेटेंट आहे, मी जर काही त्याच्यावर मॅन्युफॅक्चरिंग करू शकत नाही तर मी एखाद्या कंपनीला विकेल, अधिकार विकेल आणि त्याची रॉयल्टी घेईल. रॉयल्टी म्हणजे काय, समजा मी तो पेटेंट विकला आणि त्यांनी 100 प्रॉडक्ट तयार केले, तर 100 प्रॉडक्ट पैकी मी ठरवून घेईल मला 10 प्रॉडक्टची किंमत मला भेटेल, 90 प्रॉडक्टची किंमत त्यांना भेटेल, कारण त्यांनी ते कमर्शलाइज केलेलं आहे. किंवा दुसरं, मी एखाद्या बिझनेस मध्ये त्याला माझा जो फॉर्म्युला आहे तो देईल किंवा कंपनीला देईल आणि त्याच्यापासून जे फायनान्शियल बेनिफिट आहे ते मला मिळते. देन मग आयडियल पेटेंट, हाऊ इट शुड बी, इट शुड बी व्हेरी बॅलन्स्ड अँड सायंटिफिक. Since it is a techno-legal document, it should have a scientific proof. And the rules and the skills they are required for drafting the patent. When you are writing or drafting any patent, you should aware of all the rules according to the Patent Act and timely the amendments, the changes they have done by the government of that country. So depending upon that, you should draft the patent. So you should have a futuristic approach. भविष्य कशामध्ये आहे त्याच्यावरती आपण काम करायला पाहिजे. आपल्याला माहिती आहे भविष्यामध्ये कुठल्या कुठल्या गोष्टीची रिक्वायरमेंट आहे. आता मेडिकल डिव्हाइसेस आहेत वेगवेगळे. आता परवालाच एक नोटिफिकेशन निघालं की 12वी पास विद्यार्थी ते मेडिकल डिव्हाइसेस विकू शकतात. मग त्या मेडिकल डिव्हाइस मध्ये आपण रिसर्च जर करत गेलो, आता प्रायोरिटी आहे. नाउ द प्रायोरिटीज आर 2 things only. One is the education and second is the health. So in that 2 field, we can make a lot of money. So that's why we should have a futuristic approach regarding that. And if you are having a limited claim, then it is not beneficial for the patentee or applicant. So when you are filing or drafting a patent, the more and more number of claims are there, our research will keep away our competitor very, very much. And it is very, very safe for us. Okay. And we can have a more commercial value of our product. Then that patentee or inventor should do in-depth research regarding the prior art. आता तुम्ही म्हणाल prior art म्हणजे काय? So whatever the different patent or prior art means a research that is already done before. Research that is already done before. It may be in any book, available in any book, or it may be available in research articles or review articles or in any the patent domain. Okay, we should read that so that we should not enter in the field of other. Yes. So it avoid the infringement. It will avoid the infringement. So if I have to file the patent, what should be the different steps that we must understand? Number 1, I must understand the innovation What are the three properties of innovation? Number one, novelty, non-obviousness, and applicability. If these three things are available, okay, I am going to draft the patent for that. Okay, so if I am drafting the patent, after complete drafting in a scientific as well as techno-legal skill, I have applied over there. I have prepared a total application. Now, application I have told you they are of two types. One is a provisional application and second is a complete application. Provisional means if I got the idea and I will file that particular patent in the provisional, and in 1 year only I have to submit the complete document to that particular in that particular patent office in that particular jurisdiction in the supplement to the provisional application. Then once I file that application, from the date of filing that application, it will publish in 18 months. 18 month, there will be publication, and it is compulsory. But if I want early publication, so I have to pay extra fee. I have to fill some form that is available on the website, and I can do the fast track publication of that. I can request for the fast track publication. Then examination. Examination is not automatic. From the date of filing, if I wish the examination of my patent should be I want the evaluation of my patent, then I have to fill the application for that along with that examination fees. Then after 48 months, it will be evaluated. Okay, and after that evaluation, if there is any deficiency or technical means mistake that is present in your patent, they will send you back regarding the correction. You have to overcome that particular corrections, and again you have to submit it to the patent office, and then they will take the decision whether to grant that particular patent or not. So I have told you, normally this period after filing of examination is 48 months. But if you have not paid the fees and you have not given the application for the examination within that 48 months, what will happen? The validity of your patent will be not remain as it is. But another side, just like a fast track publication, if you want a fast track evaluation of your patent, you can also do that. So for that, you have to again fill one new form along with the fees. So fast track publication will be there. So this is overall process of the patent filing up to the grant or rejection. Now question comes from the title page. Who can patent a patent, or who can file a patent? So any person who takes the responsibility that this type of work, it is an invention. So that is the first inventor. If suppose first inventor, he deceased, so immediately before that, a legal representative of that deceased person can file the application. Or alone I can file the application, or I can have a group of people I can file the application. Yes, anybody of us, we can file the patent on behalf of our coordinate, that co-investors or inventors. Okay, but this is a techno-legal document. A small mistake. If you enter in that particular area of other research area of other person, that is called impingement. आपण नियमाच्या बाहेर जाऊन काम करत आहे, नियमाचं आपण उल्लंघन करत आहे, आणि त्याच्यामुळे आपल्याला हेवी फाईन सुद्धा होऊ शकते किंवा इम्प्रिझरमेंट सुद्धा होऊ शकते, जेलमध्ये जाण्याची वेळ सुद्धा येऊ शकते. आणि त्याच्यामुळे हे जे काम आहे मी जर सजेस्ट करेल आपल्याला रजिस्टर्ड पेटेंट एजंट. रजिस्टर, आय एम युजिंग द नेम रजिस्टर्ड पेटेंट एजंट. So patent agents are many, but registered many patent agents, they are limited. So after that, just now we have seen that who should be the inventor. Is everyone of the team can be a inventor? Obviously not. प्रत्येक जण हा नसू शकतो, ते आपण समजून घ्यायला पाहिजे. प्रत्येक जण टीम मधला नसू शकतो. प्रोफेसर, yes, if they involve in our patent work, okay, conceptual, okay, then and then only we can include their name. Suppose if we are doing the innovation or any research in our laboratory, and I have asked my employee, okay, or employee of our college or lab technician, make 0.1 normal hydrochloric solution, and I require it for my research work. Or any peon is there, I have asked him, just wash these glasswares. Can I include his or her name in my patent as an inventor? Obviously no, because they do not involve in the conceptual development of my invention. Then he or she may be alone file the patent, or a group of people, they can come together, okay, they are called as a patentee or inventor, they can file the patent. आता असाइनी कुठं म्हणायचं, कोणाला म्हणायचं असाइनी? So ownership of the patent, when the inventors they are giving to the third party at the time of registration, they are called as assignee. समजा एक कंपनी आहे, त्या कंपनीमध्ये खूप सारे एम्प्लॉई काम करतात. So that employee make the agreement with the employer and they assign the employer for filing that particular invention. And such type of employer is called as assignee. Now, what is the exact process of flow work when you are filing or when you are drafting the patent? We must understand. First thing, brainstorm the keywords. Brainstorm. So whatever the keywords they are coming in our research, so that keywords we have to do the complete research by using that keywords on the different domains what I have told you now. Then we have to classify, initially classify. Now what do you mean by classification? Whether we have to go for a provisional or a complete specifications or application, that we should decide first. Then if patent, our whatever the research work innovation is there any relevance with the any innovation or clearly that is available in India or outside the India? So we have to check for that particular relevance. Then read the classification definition. Patent चे वेगवेगळे भाग असतात. कुठले कुठले भाग आहे? टायटल आहे, बॅकग्राऊंड आहे, क्लेम्स आहे, डिस्क्रिप्शन आहे, समरी ऑफ इन्व्हेन्शन आहे, डायग्राम्स आहे, ड्रॉइंग्स आहे. तर या प्रत्येक पार्ट मध्ये काय काय यायला पाहिजे ते आपण समजून घेणं गरजेचं आहे. पेटेंटची बॉडी काय असली पाहिजे, पूर्ण एनाटॉमी काय पेटेंटची हे आपण समजून घेतलं पाहिजे. त्यानंतर सर्च बेस्ड पेटेंट अँड पब्लिश ऍप्लिकेशन्स. आपण पूर्ण जे पेटेंट आहे ते सर्च करायला पाहिजे. मग प्रत्येक पेटेंटची प्रत्येक लाईन वाचणं गरजेची आहे का? आपल्याला वाचू शकतो का? आपण नाही वाचू शकत. मग त्याच्यासाठी कीवर्ड्स वापरतो. किंवा पूर्ण रिसर्च मध्ये ऑलरेडी काय हे त्याच्या टायटल वरून कधी समजणार नाही आपल्याला, पण त्याचं बॅकग्राऊंड किंवा ऍब्स्ट्रॅक्ट जो असतो त्याच्यामधून आपल्याला या गोष्टी समजत असतात. देन पब्लिश्ड ऍप्लिकेशन, ऑलरेडी जे पब्लिश झालेले आहेत आणि जे ग्रँटेड ऍप्लिकेशन्स आहेत पेटेंट्स, ओके, वी शुड रीड देम इन डिटेल and then depending upon that we should review our claim, specifications and the drawing, and then finally we should put the references for that. So these are near about 30 forms they are available for filing the patents. Okay, so out of that few are important for us. That only I have included here. Okay, so what is form number 1? So it is a covering letter to the controller. of that particular jurisdiction. Specifications, provisional and complete application, form number 2. Then statement and undertaking, it is present in a form number 3. Request for extension of the time. मी तुम्हाला सांगितलं, मी जर प्रोव्हिजनल ऍप्लिकेशन फाईल करत असेल तर मला दिलेला टाइम किती असतो? 1 वर्षाचा. फ्रॉम द डेट ऑफ फायलिंग ऑफ प्रोव्हिजनल ऍप्लिकेशन मला गव्हर्नमेंट किती वेळ देतो किंवा पेटंट ऑफिस फक्त 1 वर्ष देते. 1 वर्षाच्या आतमध्ये मला कम्प्लीट स्पेसिफिकेशन सबमिट करावं लागतं ऑफिसला. जर नाही केलं तर माझा पेटंट तिथून डिबार्ड होऊन जातो, माझा ऍप्लिकेशन तिथून डिबार्ड होऊन जाईल. मग अशा वेळेला मला जर 1 वर्षापेक्षा जास्त वेळ पाहिजेत असेल तर मला फॉर्म नंबर 4 भरावा लागेल आणि त्या फॉर्म नंबर 4 सोबत मला काही जी फीस त्यांनी डिक्लेअर केलेली आहे ती वेळोवेळी चेंज होत असते, म्हणून मी इथं कोट केलेली नाही. डिक्लेरेशन ऑफ इन्व्हेंटरशिप ही आपली अंडरटेकिंग असते. जे इन्व्हेंटर म्हणून सांगतात, ज्यांचे नाव तिथे येतात त्यांची इन्व्हेंटरशिप फॉर्म नंबर 5 मध्ये असते. And if any change in the applicant, if suppose any of the earlier applicant, we have to withdraw the name of that particular applicant, or you have to introduce the new name of any applicant, then the form number 6 is also there. The mentioning of inventor. Okay, there are 2 different things. All inventors are applicant. All inventors are applicant, but all applicants are not inventor. Okay, सगळे इन्व्हेंटर हे ऍप्लिकंट असू शकतात, पण सगळे ऍप्लिकंट हे इन्व्हेंटर असू शकत नाही. मी आताच तुम्हाला असाइनीची गोष्ट सांगितली. आपण कॉलेजमध्ये समजा काम करत आहे, आपण खूप जण आहे, 10-12 जण आहे आणि आपण त्या इन्व्हेन्शन वरती काम करत आहे. आपण सगळे इन्व्हेंटर आहे, पण आपण असाइनी कोणाला ठेवलेला आहे? एम्प्लॉयरला ठेवलेलं. मग अशा वेळेला असाइनीचं नाव कुठे येईल? इन द ऍप्लिकंट, अँड वी विल बी द इन्व्हेंटर्स. ओके, रिक्वेस्ट फॉर अर्ली पब्लिकेशन, दॅट इज कॉल्ड एज फास्ट ट्रॅक पब्लिकेशन. देन रिक्वेस्ट फॉर एक्झामिनेशन, फॉर्म नंबर 18, अँड ऍप्लिकेशन फॉर फास्ट ट्रॅक इव्हॅल्युएशन, that is form 18A. Then power of attorney. जर मी स्वतः पेटेंट फाईल करत नसेल तर मी माझे अधिकार कोणाला देतो फाईल करण्यासाठी? जर पेटेंट एजंटला देत असेल त्याला म्हणायचं पॉवर ऑफ अटर्नी. त्याला काय म्हणायचं? पॉवर ऑफ अटर्नी. देन फीज कशा स्वरूपात भरतो? जर लोकल चेक इन हँड जर आपण जाऊन तिथं देत असो ऍप्लिकेशन, लोकल चेक तिथला असला पाहिजे, त्या टेरिटोरी मधलाच असला पाहिजे, त्याच गावातला असला पाहिजे. डिमांड ड्राफ्ट नेऊ शकतो, तो कुठेही चालतो. देन कॅश असू शकते किंवा ऑनलाईन तुम्ही फीस पे करू शकता. सो दिस इज द वेबसाइट. ओके, इफ यू क्लिक इट यू कॅन डायरेक्टली गो टू द वेबसाइट ऑफ india.ip.gov.in. Okay, so you can have attachment to that particular. Now, how to draft patent? So here I will speak more over regarding the Indian patent. It should be in a English language or in a Hindi. Okay, in India, these 2 languages, they are permitted by the controller. So your patent should be draft legible, clear and widely spaced. Legible म्हणजे clearly आपण वाचू शकलो पाहिजे त्याला. आणि widely spaced असलं पाहिजे. 1.5 किंवा 2 ची स्पेस जनरली ठेवली जाते. It should be hand written or typewritten or in a printed form. Nowadays we are just following the printed form. You have to prepare that particular draft on A4 size white paper. You have to custom the margin for that. 4 centimeter from the top and 3 centimeter from all the sides. So one minute. So these are the customized way in which we can file the patent. Now, firstly come to the title page. First page of the patent, printed page or a granted patent, if you can see, So it contains the title, then name of inventors followed by the applicant. Okay. Yes, anybody is having difficulty? Azza Sheikh, you have raised your hand. Okay. So this is the title page of your draft. It should contain the title of invention, then name of inventors, the patentee, who are the patentee, with the co-inventors and the applicants, date of priority, means filing the patent, then category, whether it is a product patent or process patent. So depending upon that. Okay. So these numbers, they are given on the front page of the patent. Then field of invention. So if it is a science, then it is also included on that particular patent first page, so that that office will send that particular patent application for the evaluation to the science people. Okay. If it is a pharmaceutical sciences category, it will go to that category, or it will go for evaluation to that particular referee. Okay, that is having that particular specialization. So that's why on the front page only, the field of invention it is given. Then abstract. Abstract means a SAR. Okay, so it contains a brief information regarding your patent. Okay, and this abstract is very, very short, near about 150 words, not more than that as per Indian Patent Act. Then figures and drawings or flow charts or diagram with small description, and that how many total number of pages they are present in your patent, and how many number of claims are there. So that is given on the front page of your disclosure form. Then next page, from next page, there are complete specification and the description of the patent. It is started. It fully discuss about what is innovation. So what is your work, how it is designed, and what is its application, and what is the use of claim. So claim, they are setting a legal boundary so that our competitor cannot enter in our area. So if you see this word claim means C means Chakravyuha. Okay, if the more the number of claims are there, so more the number of layers. If you cut the onion, okay, you can see the number of layers. Okay, similarly, if claims are more, so more and more difficulty for the competitor to enter in your field. Okay, so if they tries to get your product or process, they will infringe and they have to pay for that. So these are the main part. Okay, so what is there in this description of invention? So why this particular objective? What is the objective? What is the purpose of our invention? So why we have done that particular invention? Then technical description. Then what are the advantages for the earlier inventions? If the earlier method is available, if it is new, then it's very, very good. If it is not done earlier, but if it is done before, what extended work you have done? And if you have done extended work, what is the advantages of your work over the earlier one? So that you have to explain. Then economic potential and commerciality of your patent. तुम्हाला फायनान्शियली किती फायदा होणार आहे, कमर्शियली किती फायदा होणार. Commercial applicability, industrial applicability is very, very important. So problems which invention seek to solve. So it solve which type of problem? Your patent, it solve which type of problem? That should be described in a description of an invention. So first, background of invention about the prior art. So propose, for what purpose? We have a detailed knowledge of prior art. Prior art म्हणजे काय? भूतकाळामध्ये कोणा त्या फील्ड बद्दल काम केलेलं आहे याची माहिती. So whatever the work done and what is required whatever the gap is there, that we have to fulfill by the invention. Okay, by the invention, and that is called as new invention. Okay, what is the solution for that? So information, whether work has been displayed, reported, published, presented anywhere, we have to check first that, and then we have to give the declaration. So as the other work, this particular work that is done earlier, okay, and this is the extension of that work, and it is not published anybody earlier, and this is the applicability of my work. Such a declaration we have to give at the end of our presentation of that particular patent. So these 3 slides, they will show the total information regarding the patent. Now one by one we will go to each point. So title, it should be general. So from title, we should not understand so much. It should be vague. Okay, so that anybody cannot understand what is there in our patent easily. Clearly capture the features. It should catch the different properties like a apparatus, process, and the product name in our title only. Okay, it should be fairly catchy. Then concise, precise, and meaningful. It should have a meaning. Concise means it should be short enough and precise, related to that particular subject. And it should not be too long. Means not more than 150 character or 10 to 15 words. So the title should be short as possible. And it is the heart of the invention. Title is the heart of invention. And it comprises of all major aspects of claim. So what we have included in the claim are very, very important part of it. So the reflection of the claim should be the title. Then field. We सांगितलं field ची गरज कशासाठी? So it highlights the subject or field of invention and generally starts with the general discussion of the topic, and examiner, they can classify the patent accordingly. सायन्स आहे, सायन्स कडे जाईल, फार्मसीचा आहे, फार्मसी कडे इंजिनिअरिंगचा आहे, इंजिनिअरिंगचा आहे, मेडिसिनचा आहे, मेडिसिन, आर्किटेक्टचा आहे, and architecture. So from the front page only we can understand what is the field of innovation, and depending upon that it will go to the referee, and it will be very, very easy for the patent office to do that. Then background, which is the next part. It expresses more detail about title. Provide the utility of prior art and drawbacks. अगोदर जी रिसर्च झालेली आपल्या फील्ड मध्ये त्याचे ड्रॉबॅक्स काय, इन व्हॉट सेन्स, त्याचे ऍप्लिकेशन जे होते त्याचा परफॉर्मन्स कमी होता, त्याची कॉस्ट जास्त होती, त्याची सेफ्टी कमी होती, आणि बाकी कुठल्या लिमिटेशन्स काय काय होत्या प्रायर आर्टच्या अगोदरच्या ज्या गोष्टी अवेलेबल आहेत किंवा ज्या प्रोसिजर अवेलेबल आहेत त्याच्यावरती आपले ऍडव्हान्टेजेस काय. सम टूल्स फॉर सर्च इन अब्सेन्स ऑफ ऍब्स्ट्रॅक्ट. आता काही देशांमध्ये जे पेटंट पब्लिश होतं ज्याच्यामध्ये ऍब्स्ट्रॅक्ट असतो त्याच्यामध्ये बॅकग्राऊंड नसतो, पण ज्याच्यामध्ये बॅकग्राऊंड असतो तर बॅकग्राऊंड मी पूर्ण पेटंट आपण वाचू शकत नाही, त्यावेळेला आपण त्या बॅकग्राऊंड पार्ट जो आहे त्याचं वाचायचं. इंडियन पेटंट मध्ये ऍब्स्ट्रॅक्ट हा पार्ट असतो, त्याच्यामुळे बॅकग्राऊंड तुम्हाला दिसणार. इंडियन पेटंट मध्ये काय असतं, बॅकग्राऊंड हा पार्ट नसतो, कारण आपल्या याच्यामध्ये इंडियन पेटंट मध्ये, युएस पेटंट मध्ये आणि विपो म्हणजे इंटरनॅशनल पब्लिकेशन मध्ये काय असतं तर ऍब्स्ट्रॅक्ट हा पार्ट असतो आणि त्याच्यामुळे तिथे बॅकग्राऊंड तुम्हाला दिसणार. So provide the technical background to our inventions, and it finds the gap between what is required and what is available, and it proposes the merits over the earlier inventions. So how we can write this background? So write up what is known before. So already what is done, in short we have to write it, we have to summarize it, then we have to identify what are the problem, okay, in the earlier art, known art, okay, and how that problem I am going to solve with my invention. And if I solve with my invention, what are the advantages of my invention? And in India, it is not mandatory. मी सांगितलंय तुम्हाला इंडियन पॅटेंट मध्ये ऍबस्ट्रॅक्ट असतो, बॅकग्राऊंड नसतं. So it is the part of majorly, it is the part of description. हे बघा बॅकग्राऊंड कशापासून तयार करतो आपण, कुठलं लिटरेचर वापरतो, वेगवेगळे बुक्स हार्ड कॉपीज वापरतोय. Then research review from different databases, Science Direct, Scopus, Web of Science, Nature, Springer, PubMed, Sci, MDPI, JAMA, and ResearchGate. So these are the different sources from which what we are doing. We are just searching the literature along with the different patent offices website like a USPTO, WIPO, European Patent Office, database, SIPO, and DPMA, and JPO, and IMPR. So these are the different databases, they are available online. So on which you can have a detailed search, and from background or abstract, you can understand whether our innovation, it lies or it enters in the field of others, that we can easily understand. So what is meant by innovation for us? So no patent, it is containing our information or our solution, or it is not present on any online databases or in an article, research article or review article or in any book. And such innovations I have planned, and I am going to apply for that particular patent. And that's why this is called as an innovation. So in our application, we have to bridge the gap between what is the existing is there and what is the novel is there. Okay. Now, next part. What is the objective of our invention? पण हे कशासाठी केलंय आपण invention? It reflects the advantage of our invention. तो जुना बॅकग्राऊंड कशासाठी, कुठे गॅप सापडलाय आपल्याला, काय नीड आहे. Objective, it tells us what is the need of our work. So it should provide the solution over the existing art. And each objective or merit invention should be described in a separate sentence. Every advantage of our innovation should be written in the different sentence. So it is very, very clearly understood in a legible way and in a concise way. Then comparison between the previous inventions and proposed invention. We have to do the comparison, how we are differ from them. Then what is that improvement that is done by ourselves. That all part, it comes into the objective of invention. Then next comes a statement of invention. Statement of invention. There should be what is the novelty of our invention. It reflects the features. What are the different properties of my invention? Then useful to describing the novelty of the invention related to the independent claims, and the complements to the obvious claims in the situation of infringement proceedings. आता बघा, कॉम्प्लिमेंट टू द ऑब्वियस क्लेम्स. ऑब्वियस क्लेम म्हणजे काय, हे आपण पुढच्या पार्ट मध्ये डिस्कस करणार आहे. वेगवेगळ्या प्रकारचे क्लेम्स असतात. क्लेम्स काय करतात, आपल्याला लीगल प्रोटेक्शन देतात. कशापासून, तर आपल्या फील्डमध्ये कोणीही एंटर होऊ शकत नाही, आणि त्याचा फायदा आपण कसा करून घेतो, आपण हा नवीन नेक्स्ट पार्ट मध्ये बघणार. देन समरी ऑफ इन्व्हेन्शन. सो इट गिव्स द जिस्ट ऑफ इन्व्हेन्शन. It gives the in brief information regarding the invention. So it contains the information regarding nature, then objective, then composition, and the operation. How our invention, it is what are the objective of our invention, how we have prepared that particular product or process, and how it is operating, what is the application of our invention. Okay, so all that are included in a short, in the summary. It understands the claims of specification in detailed description. So all complete specifications, okay, they give us more detailed information regarding this short information of the summary. Now, furthermore, the summary mentions the solution to the problem that is talked in the background. Background मध्ये जो problem आपल्याला arise झालाय. So initially research literature, problem arise, then in innovation we are solving the problem, and that will finally we will summarize in the summary. Then citation. So when we are doing the extensive review of literature from different books, from different articles available, okay, and the patents, okay. So what are the references? They are relevant to our research or innovations, that only we are including in our patent drafting. So what are the previous inventions upon which our patent is proposed? Then next part is the drawing, description of a drawing. We know that drawing is very, very helping aid, and one drawing is equal to 10 sentences. If you draw one diagram, it can tell near about 10 information similar to the 10 sentences. And for one part, just you have to do one sentence. Means briefly you have to term each part with their functions. And always there are specifications, they are given in the particular description, how you have to prepare that particular patent. In that only the specifications of a diagram they are given. So what should be the size, okay, what should be the height of the patent, what should be the breadth of the patent, everything it is given, and all the names you have to give in the right side. Okay, figure you have to set at the left side of the page, and all the names you have to give on the right side. Names on the right side get correct. That is the correct option for that. So drawings are appended to the application. Drawings are present at the end of the application and must confirm the technical requirement stated by the respective patent office. मी आता सांगितलं तुम्हाला जे पेटेंट ऑफिसनं स्पेसिफिकेशन्स डायग्राम साठी दिलेले आहेत, फ्लो चार्ट साठी दिलेले आहेत, ते सर्व आपल्याला फॉलो करायचे. And each atom in the drawing is numbered. Every atom firstly numbered, and then that numbered, okay, that we are using in the description during explaining the detailed description or specification. So same number may be used to refer the identical part in the several drawings. So each number must be unique. Okay, one number should be used one time only in the diagram, and the numbers should not be consecutive. It is not compulsory. While you are writing the description, they should come in the sequence, like 1, 2, 3, 4 in the sequence. It is not necessary like that. So you can arrange them structurally or functionally depending upon the need. Then drawing can be a diagram, it may be a flow chart, or it may be a figure that are labeled with the numbers. Then in a summary, what specification tell us? They tell us about the art of invention, how to perform any art. And what do you mean by claims? Claims, it is the legal language that provides the significance to our patent. So claims need to be valid, and claims determine the infringement. Therefore, this claim, they should be written very, very carefully. So specification, these are the techno-legal document, contain a detailed invention regarding the technology and the claim. So it is the body of the part, patent. Okay, so this is the body of your patent. Body means it is the major part. Okay, it is very, very lengthy comparatively. So total patent, it is start from 1 page to 30 page. Okay, this is the limitation for Indian patent. Okay, and if it goes above 30 pages, then you have to pay the extra fees per page. So there is a no specification for that. A specification must describe the invention fully or completely. and sufficiently the information to satisfy the patent examiner or examinee. And it should fulfill the requirement for the patent and a drawing form, a part of the specifications. There are mainly two types of specification. I have told you, provisional specification and a complete specification. So this is the format for the complete specification, means how should be your complete patent. So title, field and background, use of invention, prior art available, that is called as background, and their disadvantages, comparison between prior art and our present invention, then aim of present invention, summary of invention, then the statement of the invention, and what are the different diagrams that we have used and their description, and working example for the best method, and last is the claim. So these are the part of different patent mainly present with the complete specifications. Okay, so this is the summary of all what we have seen. Only the claim part it is remaining. There is a big difference between complete specification and provisional specification. I have told you there are two types of form. Provisional application is there and complete application is there. So provisional we can file when there is idea in your mind. Complete application, it is necessary to get patent. You cannot patent the idea in complete specification application. It describes the nature of invention and describes the essential feature of invention. Provisional one. And here the complete specifications, what they will do? They will describe the nature of the invention and detailed manner in which it is performed. So the claims are not needed in a provisional one, but in a complete specification, the claims are needed. And in provisional, we have to provide the complete specification within a 12 month after application of a provisional specification application to the patent office. And complete means complete application, it is completely fulfilled, and that's why there is no need of the supplement. Now come to the very core and essence and hard part of your patent, and this may be your last part of the presentation. So claim must be critical part, and it is the essential part of your patent. It sets the boundary for the protection of our invention. So it sets a boundary. Nobody can enter in our field. It provides the right to exclude other from our invention. And these claims, they are enforced. Okay, they लादले जातात दुसऱ्यावर की माझ्या फील्ड मध्ये कोणी यायचं नाही. Okay, and these claims, every claim, it is starting with the word. If I am only inventor who is filing that particular patent, the new paragraph, it will start with I. And a group of inventors, they are coming and filing that particular patent, then it will start with we. We claim. Okay, and every claim should be written on the different line. So claims decide whether the competitor is infringing in our patent or not. And that's why we should write it very, very cautiously. And claims are closely examined by the patent office at the time of examination. And second thing, they are examined if any judicial cases they are occur in the court at that time. That claims are very, very important. And that's why you should write that particular claim very, very carefully. So claims specify the scope of ownership in the piece of intellectual property, and generally in a patent minimum 2 or maximum 20 claims should be there. More than 20 can be also allowed. More the number of claims, more will be the protection to your patent. But again, the limit is given. You can publish 30 pages and 10 claims. Okay. But if pages goes above 30 and claims goes above 10, you have to pay the extra fees for that. The language that is used for the claim, I have told you, every country, they will provide the different language for publishing or for writing that particular patent. In India, English, Hindi, or electronic format. For example, gene sequence is there, chemical structural formulas are there. So we are using that electronic format. So that can be also allowed to write the patent. So claims, they are having the great importance in the patent litigation in the court. This patent, they should be firstly start with the broad and they should be narrowed down. Okay. And when they are narrowing down, more the number of claims, more is the difficulty for entering or infringing in our work. And more is the number of claim, more will be the chances of patentability, that we must understand. And every claim, they are containing mainly three parts. They starts from I, we claim, and after that, what is their claim? That is called as introduction. Their claim, that sentence is called as the introduction. Then it will couple another sentence to that by using the words like a comprising of, consisting of. So you can see while writing the patent, these words, they are coming repetitively. I or we claim, and this coupling word, comprising of, consisting of, includes. So these coupling words, they are much more, and then the body of the sentence will be there. So these claims, they are supported descriptions. Hello, sir. Banginwar, sir.
Yeah, sir.
Am I audible, sir?
Yes.
Okay. So just this is the last few slides. 2 to 3 slides are remaining, and these are very important part. These claims, these are the very important parts. And mainly there are 3 types of claims based on the scope. Number 1, independent. As the name suggests, independent. It represents one feature of the patent alone. Okay, and that's why it is called as the independent one. It stands themselves, no reference to other claim. I will tell you the example, then you can understand very well. So define the scope of invention. Independent claim, they are defining the scope of invention and set the limit or element so that nobody can enter in our area of invention. So single statement, it will define a single feature. For example, claim 1. Now see, how is the language? An apparatus for moving object consisting of one or more disc axle connecting said round disc. Okay, one object is there. They are having different discs, and that disc, they are having the axle. So how many discs are there? One or more. Means I have told you, when you are writing a specification or claims, it should be broader one. So from this sentence, what we can understand? So this is a device or object. It is having one or more wheel. So is it cycle? Is it a bicycle? Or is it a tricycle? Or is it a, okay, so it will depend. Okay, so it will be depend upon the, so it is very vague. We cannot judge from that. And therefore, this particular type of statements, they are written in the patent, so nobody can enter in our field. Then they are connecting said round disc. Okay, they are connecting together and said a round disc. Now this is the first claim. Next, what done by dependent claim? Dependent claim means one claim is depend upon another. Then it is called as a dependent claim. For example, here, dependent on claim 1 and other claims. It includes the features of other claim. So claim are sequential after 1. सगळ्यात पहिले आपण we are writing the claim number 1, and claim number 2 is depend upon claim number 1. Claim number 3 is depend either on 1 or 2. Claim number 4, it is depend upon 3, 2 or 1 or all above. Okay, so depending upon that, we are writing the next draft of the claims. So claim 2, an apparatus of claim 1. See, it is containing one or more disc that is having the axle, and that is called as that particular disc. Okay, so an apparatus in a claim A for moving object. So there they have not included that it is a moving object of one or more discs, where axles are fixed to said round disc using the ball bearing. Now one more thing they have added over here. The axle is there, but they have added now ball bearing. Means first your claim was broad, independent claim was broad. They have told us now bearing is there. So it is narrowing. Okay, next. So this is called as, now see, this is a car with a roof. This is a claim number 1. Okay, claim number 2, object of claim 1 with a polyvinyl transparent roof. So this is a polyvinyl transparent roof that is present on the car, okay, or on the object. So they have not called here as a car. Okay, they have called as object. So object, you cannot define it, whether it is a cycle, whether it is a bicycle, okay, whether it is a auto, we cannot say that. Then claim 3, the object of claim 2 with the sliding system on the roof. If you can want to move the top of the particular car, you can move it. Means this 3 claim is depend upon 2, this 2 claim it is depend upon 1. Okay, so depending upon the scope, we are dividing them into independent and dependent claim. And next, omni claim. So when in a specification, when you are writing this claim, you are getting the sentences like this: substantially as described, substantially as described with the reference to the drawings. Okay, when you are describing it with the taking the help of the drawing, then it is called as omnibus. Substantially described herein. So as described in this particular paragraph, okay, such a sentence, if they are coming in your claim, then that is called as an omnibus, and it broadens the scope of your patent. Then, depending upon invention, whether it is a product patent, suppose any alloy, any food or any drink is there, if the claim which claim about the actual product of invention, then it is called as the product claim. If it is a process, the claim which claims about a new method that get desirable result, method of preparation or any method of analysis of any chemical or its application, okay, then it is called as a process claim. Composition, if you prepare a new formula, suppose a formula of a tea, आपण एखादी चहाच्या दुकानामध्ये गेलो आणि त्यांना चहाचा मसाला बनवला असेल तर त्याचा जो फॉर्म्युला आहे त्याला काय म्हणूया आपण, कंपोजिशन क्लेम. Then apparatus claim, a product claim which claims the device or system or article. And next, use claim, so it is the application claim of the product. Next, types of claim based on the field. So Morskun claim is there. So it is for the equivalent alternatives. So they are having the same functions. They are called as equivalent alternatives. And when you are using some chemical formula, at that time this Marcus claims they are used. Then Swiss claim. So this Swiss claim, it is applicable only in US patent. It is not applicable in India. Just now I have told you aspirin is the drug. It is initially used for the treatment of pain. Okay, that's why it is called as analgesic. But in future it was used for anti-rheumatic and then antiplatelet. So such type of claim we cannot include in India, but we can include the Swiss claim in the foreign one. Then Joseon claim. So when you are using a variant type of words, then that is called as a Jobson. So it is not also included in the Indian type of a patent. Then Burger claim is there. It is again a part of a US patent law where the computer program is written. Okay. And it is not in a hard copy type. So computer readable documents or encoded documents are available, and at that time that is known as a Burger claims. So this is the last part of the classification of the claim depending upon the structure. Pure structure. Suppose it is the method of structuring claim a part A and structure linked with the B. It's a udaharan आपण घेऊया. A switch that is connected to the lamp. Okay, a switch that is connected to the lamp. Now both are working or not, that we don't know. That is called as a pure structured base. Then structure plus function, the method structuring claim which is functionally coupled with the B. Okay, switch is there, that is controlling the light, signal lamp, that is structured coupled with the function. Then means for function, here a method structuring came where the part of invention A is element achieving the part of B. Here the that signal with the lamp. Then structure is a function. Here the structuring claim where the invention defines structure and function. That is the signal lamp. Automatically it is starting and it is getting off. And pure functioning. So the method structure claim, the part of invention A is a functioning with B in signal as well as switch. They are automatically working simultaneously with each other. Then step plus function. Here the invention A is the step for function B. So step signaling the lamp with the switch. So these are the examples of the circuit. So in the summary, I must say that how to write the claims. Claims should be broad as possible. So nobody can enter in our field. But we should not be so broad that we are entering in others' field. And claims should not be so shallow or narrow so that other people they can enter in our inventions. So next part is our abstract. So it is the brief description regarding the technology. It gives the complete specification in abstract and a summary of our matter of patent specifications, and it is not more than 150 words. So last we will file in 18 months, and there will be the examination in 48 months. Then we can have extension for that for 3 months, and we either grant the patent or rejection may be there. So in the nutshell, in the short, I must say that we must innovate, we must think out of the box, we must remain original, and we must buy original to survive in this field and to file more and more patent. So with this, I stop over here. If anybody is having any difficulty, you can type either in a chat box. I request Yogesh Banginwar sir. Now I hand over this particular presentation to you.
Okay. So thank you, sir, for a really a wonderful, in a simple language, what exactly this a patent design. We think always be a hard type of the patent, but what are example you are given in a presentation in a simple way. You can patent the simple idea in a better manner. On this note, now I requested Dr. Samir Bagade sir, Head Department of Physics, please give the vote of thanks. Over to Samir Bagade sir.
Thank you, sir. Today we have got very informative information regarding the patent. Definitely this information will help our student and faculty members in future, sir. On behalf of IPR Cell, Arts and Science College, Pulgaon, I am very thankful to Dr. Sudke sir for accepting our invitation and giving such an informative talk on draft and design of patent. I am thankful to our principal, Dr. HOD sir, for motivating us to conduct such type of programs. I would like to thank all the teacher participants and the student for attending this program. Thank you once again. And on the behalf of Arts and Science College, Pulgaon, and with the permission of chair, I would like to declare this program is over. Thank you, sir.
Okay, thank you, sir.
Thank you very much, sir.
So all the participants, please check the chat. Already I share the feedback link. Please give your valuable suggestion on today's program. So after the filling of the feedback form, there will be the e-certificate generate on directly your registered, correct email only. So please take a care. Yes, Sudke sir.
Yes, yes. Thank you very much, sir.
Thank you,
Thank
sir.
you to HOD sir, Principal, Art and Science College, Pulgaon, Dr. Y.S. Badginwar sir, NAC Coordinator, Department of Microbiology, then Organizing Secretary, Professor Shakil sir, Department of Mathematics, then Ankush Wakode sir from Department of Chemistry, and Organizing Committee, the One Day sir as well as Bagade sir, for providing me this platform for catering my knowledge regarding this. As such, the time was very, very short to explain this patent and patent drafting. So it required much more time. So I think I have some of it very, very quickly. But this time is again 2 hours. It is too much, okay, to stick all people's. So still you have attended very, very carefully. Thank you very much to all the participants also. If you have any difficulty, you can just tell to sir. I can try to solve that particular difficulties. Thank you very much, sir. Thank you. Have a nice day.
Yes, in future also, we also communicate with the different topics of the regulation affairs one. So with your a huge knowledge, we will expand it and percolate to the different students for their future. Now, with the permission of resource person, I will end this meeting.
Okay, thank you very much, sir, and have a nice day.
Yeah.
All of you.
Yes, sir.